Hello, everyone. Welcome to today's webinar, Museum Chartering 101, Mergers, Consolidations, and Dissolutions. This webinar is the second of a pair focused on museum chartering in New York State. So in case you missed the first webinar, I will be posting the link to that recording in the chat box now. I have just a few housekeeping notes to mention. If you have any sound or technical issues today, please let me know in the chat box with a direct message. This webinar is being recorded, and the recording, along with the PDF version of the slideshow, will be sent out to all registrants within the next week or so. And finally, we do have some built-in time at the end to answer any questions that may come up, but feel free to type them in the chat at any point throughout the presentation. Now, before we get started, I just wanted to share a bit about the Documentary Heritage Preservation Services for New York, for anyone who is unfamiliar with us. DHPSNY, as we like to call it, is a collaboration between the New York State Archives Documentary Heritage Program and the New York State Library Conservation and Preservation Program, with services provided by the Conservation Center for Art and Historic Artifacts. DHPSNY is a statewide program that provides free planning and education services to support the vast network of collecting institutions such as archives, libraries, historical societies, museums, and other organizations that safeguard and ensure access to New York's historical records and library research materials. DHPSNY and services include archival needs assessments, preservation and conservation surveys, guidance with strategic planning, and access to a variety of educational programs, such as this webinar. To learn more about our services, please visit DHPSNY.org. And with that, I pass this along to today's presenter, Lauren Lyons, Chartering Coordinator at the New York State Museum.
Hi, good afternoon. Thank you for joining this webinar. Museum Chartering 101, Mergers, Consolidations, and Dissolutions. So as we already covered, this is the second installment of chartering webinars that we've done. And I am the Museum Chartering Coordinator at the Office of State History at the New York State Museum. And in that position, I'm responsible for reviewing museum charter applications, which includes applications to merge, consolidate, or dissolve an existing educational corporation. So the last time we covered how to start a museum or an educational corporation, really, since you're incorporating under the Department of Education. We have some more background information on what chartering is, how chartering gets started in that previous video. So we won't really cover that again here. So today we are going to discuss mergers, consolidating, and dissolving. We're going to start with merging and consolidating, and then we'll move on to dissolving later on. So before we really get started, I want to reiterate a point from last time that our museum chartering website is really the most valuable resource for information, for sample documents, and for step-by-step directions regarding these charter actions. So if you have any other questions, please go to the website or contact me directly, but that really is the best place to start. All right. So merging, what does it mean to merge? If you're going through a merger, it means that two or more corporations are going to combine. At the end of this combination, the legal corporate existence of one entity exists and continues to exist, and the existence of the other entity will terminate. So as you can see, we have Education Corporation A and Education Corporation B. In this instance, Education Corporation B is merging into A, and A still exists at the end of this process. So merging requires an act of the regents, which means you have to submit an application to make a merger. The decision to merge must be agreed upon by the boards of both corporations or more than two. For the sake of simplicity, we're just going to default to individual corporations that are looking to merge. There must be a 3/4 majority vote from each board, and the application to formally merge can be accessed via our website, which is then completed and submitted to the Board of Regents. This application includes a petition and a certificate of approval, which should be completed, signed, and notarized according to the directions listed on the website. The petition must include signatures from officers of both organizations, and each organization must submit their own certificate of approval. So one petition, 2 certificates of approval, or 3 or 4 or 5. The original and 2 copies of these documents are sent along with the fee to merge. That's all sent to the Office of Counsel, where an initial review is completed. The application is then reviewed by my office, and if there's anything that needs to be added or revised, I'll reach out directly to you and we'll work to complete the application. And then a final recommendation can be made by my office. That recommendation is sent back over to council. They do a final review, make sure everything's squared away, and then you're put on a waiting list of sorts to be added to a future Regents agenda where you'll be voted on at a Regents meeting. These occur monthly, and following the vote on your application, you'll be notified that it was voted on and sent a formal chartering document in the weeks following. And that generally goes through Office of Counsel, not my office. So consolidating is fairly similar to merging. On our website, we put them as one category, really, when you're looking for the steps and the sample documents. So if you're looking to consolidate, that is when 2 or more corporations combine, but the corporate existence of all those entities combining terminates and an entirely new corporation is formed. So Education Corporation A, Education Corporation B, they combine, they both no longer exist, and the new entity, Corporation C, is created. So consolidating, just like merging, requires an act of the regents and requires an application to be submitted. The decision to consolidate must also be agreed on by the boards of the corporations looking to consolidate. This should be by a 3/4 majority vote from each board, and the application, like merging, can be accessed on our website and then submitted to the Board of Regents. Same as merging, requires a petition and a certificate of approval with the same signature instructions. So 1 petition with signatures from both boards and 2 separate or 3 separate certificates of approval, 1 from each entity looking to consolidate. The original and 2 copies of these documents are sent to Office of Counsel along with the fee, where they do their initial review, then it's sent over to me for a secondary review, and then back to council once everything is complete. Everything really follows the same pattern of review. So again, following the submission of my recommendation, you'll be added to a waiting list for a Regents agenda to be voted on at a Regents meeting. Following that vote, you'll be notified of the vote and sent the formal chartering document in the time following. So there are some reasons why an education corporation or education corporations might decide to merge or consolidate. They might be looking to combine resources. They might be looking to combine funding or the services that they offer to the public. So maybe you want to combine your collections. Maybe one entity doesn't have as much funding as the other, but they know that together they'll have enough funding that they can both continue on with their corporate purposes and protect the collections or create the exhibits that they want to create. So a merger or a consolidation can be between a chartered entity or an entity with a Regent certificate of incorporation. Whatever corporations are looking to combine, they don't have to have the same exact type of incorporation. So you can have a provisionally chartered entity merge or consolidate with an entity with an absolute charter, or you can have a place that has that absolute charter, they can merge with an entity that only has that Regent certificate of incorporation. However, in the case of merging, when one entity still exists, make sure that whatever entity still exists, the new purposes that you have, really they follow whatever type of incorporation you have. So if you're looking to remain a collecting entity and own a collection, exhibit that collection, care for a collection, make sure that whatever you end up with, it's a charter and not a Regent certificate of incorporation. Because as we know from the last webinar, if you have a Regent certificate of incorporation, you're prohibited from owning a collection. Okay. Now, education corporations can also consolidate or merge with not-for-profits that are not incorporated under the Department of Education. This is a slightly more complicated process, and I'm not going to delve too deep into it now because it's not as common as merging to education corporations, and that's really something to go through on a case-by-case basis. And if, for instance, if you're merging or consolidating, if by the end of that process, you're still going to be an education corporation, then that really involves our office a little more. Whereas if the not-for-profit is going to be the existing entity, that's going to have a little less of our involvement, except for making sure that collections are taken care of and nothing is going to conflict with the Regents rules or the education law. So dissolving. Dissolving can be a complicated topic. There are really, with particular cases of dissolving a corporation, sometimes it is a case-by-case basis and things that you have to do or make sure of. If you're dissolving a Regent certificate of incorporation, there's no collection concerns generally. Whereas if you're a chartered entity and you do have those collections, that can get a bit complicated. So dissolving a charter or a Regent certificate of incorporation really means that the organization is ending operations. They want to formally terminate the terms of their charter or their certificate of incorporation, and they are no longer looking to operate. So dissolving really means the end of your legal existence. An organization might dissolve because they don't have any membership. Maybe they really cater towards an older audience and you're having a hard time getting younger people involved and there just isn't a clear way forward for you. That might be a reason to dissolve. Maybe you have a lack of funds, or if you were founded for a particular purpose and you've met that purpose, you've completed your goals that you set when you were incorporated, that's another reason to dissolve. Or maybe your purpose for incorporating is no longer relevant. Maybe you're a preservation society and you were founded to preserve this one particular building or one particular type of item, and maybe that's just not something that there's a demand for anymore. In that case, you might dissolve. These, of course, aren't the only reasons you might dissolve, but these tend to be the more common ones. So, like before, everything in this office takes a really similar path towards approval. So if you dissolve, an application has to be submitted to the Board of Regents. The decision to dissolve has to be agreed upon by the board of the corporation looking to complete this dissolution. The documents can again be found on our website. The originals and 2 copies of a petition, a board resolution, and a tax affidavit must be submitted. These documents, along with a fee, should be sent to the Office of Counsel where they complete their initial review. And then it's bounced over to my office for that second review. If there's anything missing, if something isn't clear about where your collections are going, or maybe the tax affidavit wasn't filled in, you neglected to add that into the application packet, I'll reach out to you, we'll work to complete the application, and then my final recommendation will be made. Following this recommendation, you're added to a Regents agenda, you're voted on, and then you're made aware of the vote and sent formal documentation sometime afterwards. Now, dissolution does go a little further than just the Regents meeting. There are steps to take afterwards, especially if there are assets that are still held in the dissolved entity's name. So following the voting by the Regents, you should make application to the Supreme Court of the judicial district that the museum or education corporation is in to direct this disposition of any remaining assets. Any collections that are still held by the dissolved entity, this might include books, objects of art, or objects of historical significance, should really primarily be transferred to libraries, museums, or educational institutions willing to accept them. Collections are held in the public trust, and we'd like them to remain that way. So first port of call are other cultural organizations that have that collection owning, collection carrying capacity. Now, if there is a provision in the charter that's been dissolved, kind of outlining where you'd like those assets to go, maybe you have a neighboring historical society with a very similar mission that'd be willing to take those collections, that provision should be followed by the court as far as legally possible. And then any surplus funding, money, accounts, those will also be directed by the court to be given to an educational, religious, charitable, not-for-profit organization. The trustees of the museum or educational corporation can indicate where they'd like that to go in the petition that they send to the court. And on our website, we have a link to Supreme Court website where you can find what court you should make an application to. I think it's dependent on county primarily. So these three processes are primarily covered by education law, sections 216A, 233, and 220. So if you want to read any further or familiarize yourself with the language of the relevant laws, these can all be found via the general information page of our website, if that's something that you want to look into. Now, if there are particular difficulties or concerns that you have, I would also recommend hiring an attorney. We cannot give legal advice. So hiring an attorney might be the best first step, really, to make sure that everything is covered. Dissolution can be a bit confusing and a bit harrowing, and it's also, sometimes if it's a lack of funds or lack of membership, it's kind of sad to dissolve. You don't want it to end, but unfortunately, it does happen. So this was a brief presentation, but I wanted to get most of the big information out there to make sure it's accessible and you know where to go to find these applications. So if you have any questions, feel free to contact me at the phone number or the email up there. I'd be happy to work with any of you if merging, consolidating, or dissolution is something that you think you'll be going through. But we do have time for some questions now if we want to start with that. So I think we have one question already. So what if the dissolving process is not followed? We really recommend that you go through that dissolution process. Otherwise, you still legally exist and you'll be going years without submitting an annual report, and it'll look like you aren't in good standing. You don't want that legal existence to continue if you aren't operating. Now, in terms of enforcement, there isn't much that my office can do. We don't have the time to kind of follow up with every single entity that hasn't been submitting these reports and be like, well, you should really dissolve. It's something that we'd like to do, but have not been able to dedicate ourselves to currently. But do please make that formal dissolution. Otherwise, you get a little dormant note in our database, and that's not convenient really for our record keeping, and it's not convenient for yours either. So I hope that answers that question. Any other questions? Is there a minimum number of board members needed to approve dissolution? What if it's a lack of board members? That's why you're dissolving. There probably is a minimum number. I want to hesitantly say 5. I could be incorrect there. But if there's an instance where you need board members in order to approve a dissolution, whoever still exists on that board, if they want to approve new board members for the purposes of dissolving, that's a legitimate way to go. I found that many attorneys who specialize in not-for-profits are completely unfamiliar with chartering laws. Any tips on finding a knowledgeable lawyer? That is an excellent question. And the fact that a lot of not-for-profit attorneys are unfamiliar with education law, that is a reality. Education law and museum chartering is really unique to New York State. So it's not something that a lot of people are familiar with. It kind of surprises people sometimes. So finding a knowledgeable lawyer, I'm not sure if I have any advice about that, but if you are working with a not-for-profit lawyer, a specialist in not-for-profit law, feel free to forward my information and I can give them the relevant education law. I can give them a little summary about chartering and what it means. But otherwise, I don't want to give any bad advice there. With dissolutions where there are residual assets, can you go directly to the AG's office rather than the Supreme Court as you can with the dissolution of not-for-profit corporations? My office does work with the Attorney General's office on occasion. I don't actually know if they can be used in lieu of the Supreme Court. Everything that I've read usually, or have gone through, usually just mentions the local Supreme Court. I can look into that and I can find out. Anything else? New York Council of Nonprofits is a resource for mergers or dissolutions and is familiar with chartering regulations. Yes, I should have mentioned them. NYCON, New York Council of Nonprofits, they're a great resource. We work with them. If I have questions that I'm unfamiliar with, normally with not-for-profit law, I reach out to them too for questions. They are an excellent resource. So if you have any concerns or questions, especially on the not-for-profit side, they should be your first call. All right. Anything else? Anything else you want me to go over? Anything else you'd like me to revisit? If you have questions left over from the last webinar, feel free to ask those too. Nothing coming up, but maybe keep a few more seconds, see if someone's typing something. Can you review the merger process? I missed it. And what is the typical timeline once you get the paperwork for a merger? All right, I'll go over the second and then we can do a quick summary of the first. So the typical timeline once you get paperwork in for a merger. We usually advise that the whole process can take around 4 months. It can be quicker than that, depending on whether or not your application is absolutely totally complete when you submit it. If there's nothing missing, then there's no going back and forth between my office and you to get missing documents or amend anything. But the longest period of time really is when I send in my recommendation and you're put on a waiting list for that Regents agenda. That can take up to 4 to 6 weeks, depending on the cutoffs for review with the Office of Counsel. That's generally the longest chunk of time. Otherwise, the reviews can go quite quickly, especially if everything is where it needs to be and how it needs to be. So let's go back to, can you review the merger process? We can do a quick review. Sure. So merging. Merging is essentially 2 or more corporations that are combining. And when you merge, the legal corporate existence of one will continue and the existence of the other one will terminate. So you send in an application to the Board of Regents, and I want to make sure I get to the right section here. The decision to merge should be agreed upon by the boards of each corporation looking to merge with the other. This application can be found on our website, and it contains a petition and a certificate of approval that has to be completed, signed, notarized. The petition should have signatures from both boards, and both boards should send in their own certificate of approval. It's reviewed by the Office of Counsel first, then it's reviewed by me, and then it's sent back to the Office of Counsel to be put on that waiting list to be voted on by the Regents. And any other questions? Please give us your email again. Sure, I can just flip back to, there we go, charters@nysed.gov, charters@nysed.gov. So feel free to email me, feel free to call. I'm happy to answer your questions. And anything else? Well, if nothing pops up, thank you so much for attending. I hope that this was informational. I hope that it benefits and helps you all. But if there's something that I missed or something that I wasn't clear on, please feel free to let me know. I'll be happy to make any sort of clarification you need, talk through the process with you. I'm here to help. I'm here to help you through this process if it's something that you think you'll be going through or are going through. So thank you.
Thank you all for joining us today, and thank you, Lauren, for such a wonderful presentation. If you enjoyed today's webinar and would like to learn more about our upcoming educational programs, please check out DHPSNY.org/education. We have a couple of other really cool webinars coming up, as well as an online course named Archives 101. So have a wonderful rest of your day, everyone. Thank you.